Breaking news coming out tonight. A judge blocking the release of comedian Bob Saget's death records at the request of his family. Saget's family filed a lawsuit to prevent the Orange County Medical Examiner's Office from releasing additional records related to the death investigation. I want to bring in one of our attorneys, legal analysts, to talk about why this happened. Attorney Hunter Skolnick joining us here on Live Now. Hunter, I'm curious, and again, this just coming down in the past couple of hours here. Were they right in saying this? The family is saying that they would suffer irreparable harm in the form of extreme mental pain, anguish, and emotional distress if these additional records are released.
Hey, Tona, first, thanks for having me here. What's important to understand is Florida is one of those states that have wide open disclosure. Freedom of information requests are encouraged. However, under the statute, there is a clear exception in cases where there is accident or there are victims of crimes, and whether or not the release of the information can affect the victim or their families. So here there was an appropriate application made because the release in advance of the court having time to analyze the issue would have caused the harm. So the judge here today said, let's put it on hold. It's a temporary restraining order, a temporary injunction under the statute that is appropriate. Let the family make its argument in court. Let the court decide whether or not the release of this information is appropriate under the Freedom of Information Law.
So you're saying this is temporary. I believe that's a key word to note. So this could change in the future.
Absolutely. What we have here today is exactly what the court should do. You have a temporary restraining order. It is a temporary order withholding the production of the documents, the videos, the statements. I believe there may be audio information as well. So it's temporary. Let the court hear both sides. Let the court decide it on the merits, not on a quick produce the documents because there was a letter to the agency. I think the court did the right thing here. You would expect something like this, given the application.
Okay, so this is a state-to-state situation, though. Every state has its own laws, including Florida. Florida passing a law following the death of NASCAR legend Dale Earnhardt. We all remember that 2 decades ago. Records related to autopsies are required to be kept now confidential. So is that just for Florida here, or is that across the board? Kind of break it down when it comes to state by state.
Well, it is state by state. Florida has what I would call a fairly robust freedom of information law. Generally, public information, public filings, public documents would be required to be produced by any agency, whether it's a medical examiner or not. Many other states are not quite as willing to make medical examiners or medical records or information that is personal to victims or victims' families. So it is state by state. And here, there is a specific exception. They implemented a law in Florida that says if it will affect the victim or the victim's or the family of an accident victim or of a decedent, you don't just automatically produce. And that's what the court is going to consider. Both sides. They're going to weigh the merits of the application, and not all states have that.
I want to kind of take a step back here, Hunter, and talk about the autopsy itself, the death investigation. We're hearing that the medical examiner's office and the sheriff's office, they created graphic videos and photos of Saget's body, as well as audio recordings. There's been a ton of speculation surrounding this case. I'm curious what your thoughts are from the investigation itself and what has been released by the sheriff's office.
The one problem is they haven't produced enough to really reach a conclusion. What we know is that there was head trauma. We know that in any investigation like this, they will take pictures. They will examine the person's body. They will look at their phone. They will listen to messages. There may be a lot of personal information that's collected in any death situation. We know enough that it was a severe head trauma. They describe it as an accidental death. And I think there was quite a bit of investigation. And we don't know. There may be families members who called him during the course of the evening or during the day. And those messages are there, those texts. These are things that are not really appropriate for release to the public. The actual investigation, possibly. The autopsy, certain findings, possibly. But things like the statements, the investigation, personal information really shouldn't be produced under the statute.
So say this happened in a different state with different laws. Could it be possible that this information could have been made public by now?
You know, I would think in this situation where the family takes steps to withhold the production during a death investigation, I think this is not out of the norm. I'm not suggesting they wouldn't be produced at some point in time, that the press or other people requesting other information in many states would be seeking this information. But I think with a family application to withhold personal information, most courts would have granted the temporary restraining order at this point, the temporary injunction, and let the court hear both sides.
Right. And it seems like there's a couple of sides to this as well. The Orange County Sheriff's Office releasing a statement saying, well, we're sensitive to the family's concerns about the right to privacy that must be balanced with our commitment to transparency, compliance with the law, and the public's right to know. So it seems like they were intending to release it.
Well, I would think most, and having done quite a bit of work in the public sector in Florida, most governments are supportive of following the law. You release information that is kept in public files. That's the law in Florida and in many places, but in Florida in particular, it is a very strong presumption. So here, I think the agencies, the sheriff, are doing what they would normally do. They would seek to follow the law and produce. But as soon as the family comes out and says, there is information that may be damaging to us, that is unnecessary to produce under the public law, you've got to hold up. You've got to stop, let the court look at it, let them review it, and then decide what should and what should not be produced. I assure you, there will be information produced, extensive information, but there will be redacted. That's what we call it. When we take information and don't produce it, we may black it out. It may be kept altogether out of the public domain. Some will be kept out, but a lot will be produced.
So you're saying a redacted version of some of this information could be released, and that could even be photos or videos too?
Oh, absolutely. I mean, it's not uncommon that autopsy photos are produced. I mean, that is not automatically something you would ever expect an agency to withhold. Is there certain pictures that you may not produce? There could be. It's really hard to say, not knowing what they have. But there will be things, I'm sure, that are personal to the family that may not be produced here. Right. Things like these, like messages or conversations that have nothing to do with the investigation. Right.
Well, let's talk about some of that evidence possibly being leaked, sidestepping law enforcement, sidestepping the court. We saw that in the situation with Kobe Bryant, the helicopter images being leaked by law enforcement that was there. What is the possibility of that happening? And then if it was to happen, someone who was to leak it, what would they be facing in that case?
Well, unfortunately, I have seen it personally in cases that we're investigating in Florida right now, that a little piece of a investigative video was released by someone, and it's only in the possession of an agency. And it happened with Kobe Bryant. And it happens, leaks happen, and certain times people want certain portions of the file released in advance to advance a position. I'm not suggesting that's what's being done here, but it does happen. It's against the law to release this information in violation of the judge's temporary restraining order. It's against the law to produce these public documents, public information and photos until it's officially released. People could be subjected to criminal prosecution. And there's a very good possibility, we're seeing it play out in California with civil penalties, lawsuits being brought against the leaker and the employer of the leaker, and maybe the government agency, maybe the sheriff's office, if they allow something like this to happen. I'm sure they're doing their job and keeping it under wraps, but you never know when there's a rogue person looking to make a name for themselves.
Right, exactly. And there's been a ton of focus on this story, a really high profile case. Last thoughts?
I'm sorry, I couldn't hear that. I apologize.
I said, any last thoughts on this case?
Yeah, I think we're going to see in the next couple of days. This is not the type of application the court will sit on. I think the court recognizes that the public has a right to know. The press has a right to report on this. He was a high profile person. I think the judge is going to rule on this fairly quickly, and we'll see information released that's appropriate.
All right, Attorney Hunter Skolnick, thank you so much for being with us here on the show. And like we're both kind of saying, feels like it's not over. It is still a temporary restraining order on these records.
It's not over. So. Thank you so much, Daytona.
Thank you so much.